Take it, it's open now.
Yes. Roger.
Yes. You.
Good morning. My name is Ed David. On behalf of my fellow commissioners, I welcome you to this meeting of the Maine Human Rights Commission. Before we proceed with the business of today, I'm asking each of you who may have an electronic device, cell phone, pager, etc., to ensure that they are silenced. We have additional agendas, including the consent agenda, available in the back of the room and online. Consent agenda is a listing of cases in which no written arguments were made to the commission in the allotted period. The commission has voted on those cases and they will not be considered further today. The remaining cases on the agenda today are coming before the commission to determine if reasonable grounds exist to believe that unlawful discrimination has occurred. The commissioners have received and reviewed investigators' reports and any written submissions submitted within the allotted time. No new information or any written materials will be accepted today. Cases will be called in order on the accepted agenda. As I call each case, the party who has submitted a written argument will be called to the podium or recognized online to provide the most relevant arguments to the case. The time is limited to 10 minutes. Time may be reserved to rebut opposing arguments, but the time limit of 10 minutes may not be exceeded. Procedural rules of the commission specify that your arguments may address only one relevant factual areas, two relevant omissions from the report of facts submitted by the investigation, or three relevant issues and questions concerning interpretations of the law. Commission allows parties who do not disagree with the investigator's report to rebut comments made by the opposite party. Please be advised that commissioners may ask questions. I will ask that you introduce yourself as you come to the podium. And that concludes the introduction. We start with the business meeting though, did we not?
We do, yep.
Yeah.
So before you vote on the agenda, I have one item for you to consider before then, as that will affect what the agenda ultimately ends up being. We have a request in Davis v. FedEx, which is E22-0310 to withdraw the case, and I am going to break with tradition and recommend that you approve the withdrawal. Parties have reached a private settlement at the last moment, and I don't want to get in the way of that.
So move that we amend the agenda by deleting Davis versus FedEx from the hearing agenda.
Just by allowing him to
Oh,
withdraw his case.
and allowing the withdrawal. Okay. Second.
Been moved and seconded. Any discussion? All right, seeing none, if you vote yes, you are in agreement with the motion, and for our remote participation policy, I will ask that you signify your vote both verbally and visually. Commissioner David.
Yes.
Commissioner O'Brien.
Yes.
Commissioner Walker.
Yes.
Commissioner Douglas.
Yes.
Commissioner Sanders.
Yes.
Great, thank you very much. All right. So we'll remove that case from the hearing agenda, and now we can move to adopt the agenda.
And as amended, I'll move adoption of the published agenda for May.
Second.
Moved and seconded. Any discussion? Seeing none. Commissioner David.
Yes.
Commissioner O'Brien.
Yes.
Commissioner Walker.
Yes.
Commissioner Douglas.
Yes.
Commissioner Sanders.
Yes.
Great. Okay, and now we have minutes. We have minutes from both the March meeting and the April meeting, because I forgot to have you vote on the March meeting last month. So up to you if you want to take them together or separately.
I was not here for the March meeting.
Okay. Why don't we take them separately then?
I move we adopt the minutes of the March meeting.
Second.
Moved and seconded. Any discussion? Okay, seeing none. Commissioner David,
Yes.
Commissioner O'Brien,
Yes.
Commissioner Douglas.
Yes.
Commissioner Sanders.
Yes.
Okay, the April minutes.
Yeah, I move that we adopt the April minutes.
Second. Thank you. All right. So moved and seconded. Any discussion? Seeing none. Commissioner David,
Yes.
Commissioner O'Brien.
I wasn't.
You were not here, right? Commissioner Walker,
Yes.
Commissioner Douglas.
Yes.
Commissioner Sanders.
Yes.
Great, okay. Shall I move into my reports? My
Sure.
many reports. I don't know if any of you saw that I updated the agenda this weekend. This is a quarterly meeting and I am not sure if that had made it on. So I have a lot of reports. In personnel, since our last meeting, we interviewed 3 candidates for the investigator position, but have not hired any of them, so that position will be reposted. We have received and are reviewing applications for the secretary associate legal position that Chelsea vacated when she moved into the business manager position. That's all I've got for personnel. For compliance, you have a memo from Jane, 7 cases in active conciliation, no failed or successful conciliation since the last meeting, but there was a post-conciliation agreement in H23-0335 A, B, and C, Willette v. Turner Square Apartments and all. So I would need a motion to approve that agreement.
So moved.
Second.
Okay, moved and seconded. Any discussion? None. Commissioner David,
Yes.
Commissioner O'Brien,
Yes.
Commissioner Douglas,
Yes.
Commissioner Walker,
Yes.
Commissioner Sanders.
Yes.
Great. And is everybody okay if I sign for you on that agreement?
Yes,
Mhm.
please.
Great. Since the last meeting, well, in April, we had 53 new complaints filed, 27 dismissals, including 14 administrative dismissals, 1 right to sue. We had 12 cases that either settled via private settlement or our mediation program, or finally reported the terms of their settlement to me. So this number is a little bit higher than what you usually see because I got reports in a bunch of cases back, sort of all in a clump. So with those 12 cases, we have a total of about $693,000 to complainants. Yeah, I try to get those to you sort of as they come in, but sometimes I have to chase people a little bit to get the numbers. And the EEOC requires that we put at least the monetary amount in before they'll agree to dismiss a case. For quarterly reports, we have 725 pending cases, which is pretty normal, a little bit on the high end, but about where we usually are. And with an average case age of 313 days, so we're still keeping that under a year, which is good for us. We really made some progress on our backlog.
I have a couple questions. on
Sure.
that one. I like the way that this, I hadn't seen this form before, had we?
I think this is what Amy was giving you, but I'm not sure. I pulled this from the EEOC reporting.
Okay, are we talking the pending inquiry, I can't say the word, in
Yeah.
charges? Okay. I did have a couple. First, number of charges by basis. What's the difference between, I know sexual orientation, so I know what that is.
Yep.
Association.
Yep.
Then sexual orientation, sexual orientation, sex, pregnancy. Is there, what fine line between those?
No, I hadn't looked at that. So we have our own database that we use for tracking cases internally. And then we have the EEOC database. And the way we phrase our allegations and the way the EEOC phrases its allegations are just slightly different.
Okay,
So where we might categorize those all as like sexual orientation claims or sex claims, apparently the EEOC has slightly different language than what we would. They class a lot more under just sex than we would.
okay, that's right. Okay, and I probably should know it, but by case type, what is PWFA?
The Pregnant Workers Fairness Act,
Oh,
which went into effect last July, I think, but as a federal law.
okay, yeah.
And the rules for that were just published in the last 2 or 3 months for it. we have always treated pregnancy as a protected class under sex.
Right.
With familial status, we're sort of wherever that falls, but now the federal law is more explicit about it.
Okay, I'll read with that. Thank you.
Okay, I'm happy to answer any other questions about this.
Okay.
For training and outreach, you have a memo. Staff attended 16 outreach or education events. And I did just want to say the Fair Housing Summit that we had on Wednesday went really, really well. Julie was there, which was great, sat right in the front row. Thank you, Julie. And we had, for pulling something together in about 7 or 8 weeks, we had 125 attendees, which is pretty good. I think it went really well. Carrie is, I think, online. They are not in the room, but huge thanks to them. They really took point on this. It was their idea. They pulled almost all of it together. I just followed direction and called who they told me to call. So thank you, Carrie, for doing that. And we are hoping to make that an annual event because it went so well. I think a large part of that was being able to offer almost 6 hours of CLEs for $150, including harassment and discrimination and ethics. So incentive for you all to come. And we had Mandy Levine did her sort of 101 implicit explicit bias training, and she will be doing the sort of next level up after the commission meeting in June. We're all invited to come downstairs for lunch, and that she's a really phenomenal presenter. I hadn't seen her before, but it was
Very good,
yeah.
very good.
So that will be the day of the June meeting?
Yes, yeah. So we're gonna have a short agenda,
Okay,
and then we'll try to be done here by like 11:30,
okay,
and then we'll have food downstairs in the office.
all right, and that topic is what? Advanced housing?
Microaggressions, I forget what her title is actually called, but it's sort of the 201 level class on implicit and explicit bias.
Oh, okay, all right. And is that approved for credits?
It is not, but we could ask for it to be. She has gotten her classes have been approved for credit before, so yeah, we could ask.
Yeah, would you do that?
Sure.
Because it would count for the harassment and bias
Yeah,
subdivision, but sometimes it's hard to get.
yeah, and certainly hard to get like live in person instead of a live
Right.
webinar where you have to
Yeah.
answer those stupid polls on the screen every. That was so much. All right, and the last thing is that Michael, at about 1:30 p.m. on Friday afternoon, I went to his office and said, oh, by the way, it's a quarterly meeting. Do you think you could pull together a finance report that is more legible than what we have been getting from the budget office? And he did, because he is a hero. So you have, this is sort of like expenditures, what our budget looks like through the end of the third quarter,
Yes,
which was April.
end of
April?
March.
End of March.
The end of March.
31st.
So mostly I just want your feedback on how does this report work for you? Is there any information that you'd like us to have where? Yes.
Well, I mean, I had a question as I looked at it, because it is through 3 quarters.
Mhm.
Why do we come out with 35% then, and 38% of the budgets?
That's true. So what I want to look at when I see something like this at the end of the third quarter is I want to make sure that we're not less than 25%, because then we're spending too fast. If we're above 25%, then I consider that a safe zone. However, if it starts to get too high above 25%, then I start to worry that maybe we're spending too slowly. So that's definitely a good question.
I'm not following. I think thought that would be reversed.
Okay, so no, if we're at the end of the third quarter, let's say we break apart 100% into 3 quarters, we've got 25%. So at the end of the third quarter, we should have spent about 75%.
Right.
Okay, so if we're spending more than 75% at the end of the third quarter, then that would be something for me to be concerned about, because it means we have less money to spend in our final quarter. We have obviously more than 25% here, so we're on good track for the last quarter. Some things that do concern me is if that number is much higher than 25%, like it's 50%, then are we not spending enough? Did we request too much money in the beginning of the year?
Well,
So
is
that's
that what this is showing? If you've only spent 38%?
No, it's how much is left.
Yeah, that's what we've.
35% is how much is left.
Okay.
So we have more than 25%.
That's-
So I think we're on good track, and I don't think 35 is too high.
Okay, remaining balance. Got it. Never mind.
Yeah, you're
Early in the morning.
If you want us to spend some money, I have ideas.
This just comes from years of managing grants where if you don't spend, you lose for me. And so I've always been very tight at looking at money, especially in the end. I want to make sure the organization isn't going to lose money. And in this case, we're on track. We're doing well.
Good. Thank you.
And we also, in addition, we were many months behind on bills, and thanks to Chelsea's assistance, we're up to date on all of our accounts payable. So we don't have anything coming down the pike, a big chunk of payments coming down. So we're doing really well considering we're very caught up with payments.
I think we might be the only state agency that is actually up to date on all of its bills, and that is entirely not to my credit. That is these two.
When I started with the organization, I felt bad because we were a few months behind on some things, and then I was told that other departments haven't paid since 2017, so I didn't feel so bad.
We're doing pretty well.
So just to wrap up all these comments,
Yeah,
none of these numbers concern you at all. You're comfortable with
none of these
these
numbers concern me at all. No, absolutely not. I think everything looks good.
Thank you.
And if you want to see more behind this, please let me know. If you want to look at revenue or anything, please let me know.
Yeah.
And I had a couple questions. I like this. Technology, is this all this?
It is all this, and for us, it is our OIT support that we receive the support from information technology, which can be a pretty large chunk of change, but I think a lot of other things get lumped into that as well, such as any external software that we use. You know, even something as simple as Adobe licenses, they all get lumped into that. Also, what might be lumped into that is the fees for Microsoft, the fees for any other software licenses.
And this, what is our professional services and what's general operations?
Professional services are almost any kind of services that we use that aren't necessarily IT related. And those can also be pretty numerous.
We use, for example, HR, the state,
Oh,
Yeah,
okay.
accounting.
accounting,
Okay,
payroll
okay.
processing, that sort of stuff.
Okay,
But they're not our mediators.
They're not our mediators.
They're not our mediators. No, that's correct. They're not our mediators. Mediators go into, actually, no, mediators may go into professional services for legal.
okay. You think that professional services?
Yeah.
The mediation program is largely self-funded, and we did just finally get contracts with the mediators finalized for the next 2 years, so.
Yeah, because if you look at the last column here for mediation, you'll see that the 13,700, all of the mediation payments are in professional services.
Yeah. But they come out of that mediation fund and not the general fund, so that money actually doesn't come from the state, that's the parties pay to participate in mediation, and then it just goes right back out to the mediators.
And general operations?
General operations is the state funding. So that's where the great majority of our expenditures are charged to is.
Okay.
So the first column, the general fund is state funds, the next two are federal funds,
Right,
those are grants, and the next three are special revenue
right,
accounts.
right. But underlying general operations,
Yeah.
under general, the first state funds,
Oh, did you get any breakfast at all?
what is the, what is lumped into general op? I don't understand.
Under travel expenses, Michael, there's general operations.
Under it,
Yeah, and expenses.
Oh, general operations, honestly, it's a catch-all.
okay,
It's a catch-all, it's almost a miscellaneous, it's a catch-all for anything that doesn't fit very nicely in some
Okay.
other home.
okay, thank you,
It can be something as simple as the coffee that we bring here.
okay,
If we were to bring danishes here, it's a catch-all.
That's
All right.
realized.
okay, thank you.
And any organization you look at, there's usually gonna be some kind of a miscellaneous
Right,
account
right.
for things that don't fit nicely into some other
Right.
bracket.
All right, and the last thing is new business. The legislative session is over. They actually ended on time. One of our bills died on the appropriations table, so we will try again next session.
Not entirely true yet.
Yeah.
Is it not?
When they come back for veto
Oh, God,
day,
right.
they sometimes run through the approps table.
Fingers crossed. And this is the bill that would correct a couple of references in our law and also change Barbara's position to major policy influencing. So it does have a very tiny, like $3,000 fiscal note attached to it. But because they were trying to get that on time, they just didn't get to it. And lobbying appropriations is like trying to catch fish with your bare hands. So I will try again on veto day. We'll see if I get anywhere. But if not, then we'll bring it up next session. And probably split it into two bills. I have learned some things this session. The law that protects, so a law went into effect, well, it didn't go into effect, but it passed in January when the governor did not veto it. That would expand the classes that we protect for public entities, which essentially is jails and prisons. Up until now, we have only covered denial of services based on disability. As of July 17th, we will cover basically everything, all the protected classes that we cover everywhere else. So race, sex, sexual orientation, gender identity, religion, we will cover those in public entities. So we will be working on materials for that.
Was it simply an oversight?
No.
Legislation?
No, we've been working on this for several years. And then we stopped proposing the bill and Speaker Talbot Ross put it forward last session because of the general chaos at the end of the last session. The bill was passed by the House and Senate, but the governor had, I think there were like 4 days, and the governor has 10 days to veto a bill. So when they came back, there were 6 more days that she had to veto it, and she didn't veto it. So it went into effect on like January 7th or something, which was a Saturday. Didn't go into effect. It passed. I'm still learning the terminology for all of this. But anyway, it goes into effect 90 days after the end of the legislative session, like any other law that passes this session. So July 17th, we'll have a lot more of those complaints that we can process.
Do you get them now and turn them away?
Yeah, we dismiss them because we don't have jurisdiction.
Right, no jurisdiction, a fairly substantial volume of them, or?
No, it's not gonna, we didn't attach a fiscal note to this bill. It's not gonna increase the work that we do significantly, especially across, as it sort of gets spread across investigators, and some of those cases will drop out before they get to investigation, like most of them do. We still will dismiss it if it seems like they haven't stated a claim or we lack jurisdiction for other reasons, but for that population, I think it will feel like a pretty significant expansion. There definitely, we have had cases even in the last 2 or 3 months where we would have had jurisdiction over them. If this had been that. All right, we are running a little bit behind. But Ed, I'll leave it up to you if you want to take a break or move right into the next hearing agenda.
Let's go right into the hearing agenda. I know this is folks outside the door. Do they need to be
Yeah, I'll
invited
let them
in? Or?
Go ahead, Ken.
Yeah.
All right, are you all here for the meeting? Come on in.
So the first case for hearing this morning is Molly Hooser versus IDEX Laboratory E22-0104. It is a recommendation of no reasonable grounds, and therefore rules would call for hearing from the complainant first. Is anyone here on that? No?
I'm here for respondent.
Thank you.
I think we would be expecting Attorney Matz or Attorney Nucci, or Ms. Weiser.
I think, wasn't she pro se in the response that we had?
No, I think that was written by her attorneys, but signed by her.
There's someone without a description, I'm not sure.
The iPhone?
Yeah.
I don't think that's them.
Okay.
Attorney Matz or Attorney Nucci?
Do you want me to check the lobby? There's still a lot of people.
They're in New Jersey, so I'd be surprised if they were here, but yeah, go ahead and check just in case.
Or yes.
Wait.
So last call for complainant in E22-0104, Mary Boozer versus IDEX Laboratory. Respondent is here. Complainant is not here. We often entertain a motion at this point.
Yes, yep. If you had any questions for the investigator, Angela is here.
Angela's here.
But you certainly don't have to if you'd like to just move to accept the findings of the investigator's report. That's generally what we do in these cases.
Personally, I do not have any questions for it, so I'll make the motion that we find that there's no reasonable grounds to believe that respondent discriminated on the basis of sex, age, or disability, and no reasonable grounds to believe that respondent retaliated.
Second.
All right, it's been moved and seconded. Any discussion? Seeing none, the motion is to find no reasonable grounds on both recommended findings. If you are in agreement, you will vote yes. Commissioner David,
Yes.
Commissioner O'Brien,
Yes.
Commissioner Walker,
Yes.
Commissioner Douglas.
Yes.
Commissioner Sanders.
Yes.
All right. Findings are no reasonable grounds. We appreciate you being here, Attorney Parsons, and thank you, Angela. The commission will send a letter to the parties and the council confirming the results of the hearing. Great to see you.
Now I can go to my son's choir concert.
Oh, great.
We did that on purpose.
It's a surprise.
Thank
We
you.
try to help out. Second case on the agenda is Nelson versus CNL Aerospace Holdings, E22-0122. Again, it's a recommendation of a finding of no reasonable grounds, so we would hear from complainant.
Attorney Black? Oh, and yes.
So I need to recuse myself
Alright.
on this matter, so I'll be joining the gallery.
So
Glad
noted.
you remembered because I did not. Despite having had that conversation 40 minutes ago. All right, Attorney Black, you have 10 minutes. Do you want to reserve any of your time?
Yes, if it's acceptable, I'll just reserve the balance of my time, whatever that may be at the end of this.
Whenever you're ready, go ahead.
Okay, thank you. Good morning. My name is Eric Black and I represent the claimant, Mr. Nelson, in this matter. This is a case where my client worked for CNL Aviation for approximately 5 years as a lead welder. This is a case where my client blew the whistle a couple of times in the last 3 months of his employment. There are two whistleblowing acts in this case. I'm going to focus much more heavily on the second one, although I'm happy to talk about the first one if it comes up. The first one did not result in an adverse employment action, just enhanced scrutiny of absences, but we included that in our fact pattern because we think it establishes a pattern of behavior on CNL's part. On the first issue, he complained to his manager about safety concerns regarding a service door. The concerns were ignored and his absences were scrutinized thereafter, although in our view, they were resolved once he provided information establishing that he was absent due to chiropractic appointments. The second whistleblowing issue was July 7th, 2021. He reports what is a clear violation of OSHA regulations. CNL had decided to store some industrial paint in a refrigerator where people kept food and other consumables. There's no doubt that this happened. We have a picture of it that we submitted to the commission. You can see industrial paint right in the same refrigerator as Hershey syrup, whipped cream, etc. This is a violation of 29 CFR 1910.141G4, which states that no food or beverage shall be stored in an area exposed to toxic material, period. He brought that issue to his manager's attention, and he's fired a few days later, out of the blue. Keep in mind, Mr. Nelson had no progressive discipline at CNL for the 5 years he worked there, and it came as a complete shock to him. He was stunned. Why was he fired? At the time, they didn't have a termination letter prepared, but they went back and wrote one. And that's the same letter that was submitted to the commission a couple of times with the charge of discrimination and also attached to the objection to the investigator's report. And it says two things, basically. One is that he left work early on July 7th without permission from a supervisor. And two, that he took July 8th and July 9th off without notice. In our view, these rationales are false and or misleading. As to the first issue, there's just no evidence he violated a CNL policy. He was in there early that day because he'd been given an order from the company that a particular project was an emergency and needed to be done that day. He came in 2 hours early, finished his normal shift. His boss was tied up in meetings, and he asked the scheduling manager if he could go home, and she said yes. At the Issues and Resolutions Conference in this case, the general manager never said that the service manager was wrong to give him permission or that her permission was insufficient. The service manager didn't tell my client, oh, I can't give you permission, you have to wait for your supervisor. And the GM also said that he wasn't sure if Mr. Nelson was aware that he needed to speak to the supervisor. And Mr. Nelson also had to ask permission to go home because it was a violation of a rule if he stayed and worked overtime without permission. So he was in sort of in a damned if you do, damned if you don't sort of situation. And in the text message conversation, which I know the commission has, and we'll talk about that in a second, the supervisor notably never chastises my client for leaving early. As to the second issue that he took off July 8th and 9th without notice, in our view, that's just false. As you can see from the text message conversation, he clearly asked permission to the supervisor. The supervisor did not deny him that permission, and he could have. He could have said, no, I'm sorry, can't do it. Doesn't matter if people showed up unexpectedly to work on your house. We really need you here. He didn't do that. He said, if you need to take care of house stuff, then I guess we'll have to catch up next week. My client even said, I can come in tomorrow. I have some flexibility. But he showed up the next workday on Monday, and he was fired. Now, once we presented that to the Maine Human Rights Commission with our charge, complete with the text message conversation, CNL had an entirely new rationale. Suddenly, it became about a coworker who had complained about my client. And then according to the general manager's testimony at the Issues and Resolutions Conference, this was the real reason he was terminated. The coworker was going to resign because of my client, and they decided to fire my client instead. Okay, well, were these issues between these two individuals, my client and this coworker, documented anywhere? No, there was no discipline relating to this coworker at all. Okay, did they even speak to my client about this coworker, this alleged issues that this coworker had with my client? No, they never did. Essentially, according to CNL, the company just believed everything the coworker said about my client and terminated him in response. And that's not how a company acting in good faith would behave. Now, it's not illegal for an employer to behave irrationally when making a discipline decision, but when somebody just blew the whistle a couple days earlier on an OSHA violation, that suddenly becomes highly suspect. Even more so when you consider that the coworker had put in his notice on June 28th. So 9 days goes by, and my client still has a job, and it's not until my client blows the whistle on July 7th that he's fired his very next working day that he's in. So CNL tells my client on the day of his termination it has to do with absences, no mention of the coworker. When he files his unemployment claim, the Maine Department of Labor, CNL also says it has to do with absences, no mention of the coworker. We file our charge, provide this text message evidence, and suddenly the argument is, well, yes, there were absences, but the real reason is this other coworker issue. So they're telling my client in the Maine Department of Labor one thing, and they're telling the Maine Human Rights Commission something else in our view. So to bring this back to the investigator's report, the investigator found that the record shows that the complainant was discharged because the general manager wanted to retain coworker, and that the general manager would have dismissed my client even if the absences had improved. With respect, we don't think the record does show that because CNL has claimed two completely different things at different times and to different entities. The investigator found that the complainant has not provided any evidence other than speculation to substantiate his claims. Again, we respectfully disagree. The record shows that CNL told my client in different state entities different things at different times. The record shows that on the first rationale of absences, that my client didn't really violate a CNL policy. He was given permission to leave early, and he was given permission off for those 2 days. The record shows that when we produced that evidence to the Maine Human Rights Commission, CNL stated a new rationale. The record shows that my client blew the whistle on an OSHA violation. The record shows that my client had no documented disciplinary history with his company for his 5 years he was there. The record shows that this coworker put in his notice 9 days before my client blew the whistle, and that my client kept his job during that time. And the record shows that after my client complained, he was out a few days later. In my objection, I also addressed a cat's paw issue and what I believe may have been a potential misunderstanding concerning that issue. And I also discussed the validity of the whistleblowing claim itself. I'm happy to talk about those, but I am likely running out of time, so I'll reserve the balance of my time. Thank you.
Right, so you have 3 minutes when I come back to you. Any questions for complainants counsel? Sorry, I always forget that. Commissioner Douglas.
Attorney Black, good morning.
Good morning.
Yeah, so I'm just looking at, well, before I go there, first of all, I found your written submission to be quite compelling. I thought you did a really nice job
Thank you.
articulating your case. You made some really good points. On that second whistleblower act, the pain in the refrigerator, right? The report says on page 6 that complainant failed to show any other causal link between the whistleblowing, that second incident, and the adverse action. Now, you point out in your submission that he blows the whistle, 2 days later he's fired, as opposed to the absentee stuff that happened, I think, weeks before, you say. So aside from the timeline, which I understand your point there, what's the evidence that the whistleblowing caused the termination?
Sure. Thank you for the question. To a certain extent, most of these cases, and I know I don't need to tell this commission this, turns on a certain amount of circumstantial evidence. It is very rare to find, written in a personnel file, yeah, we fired this guy because he blew the whistle on an OSHA violation. So you have to look at the circumstances of what was going on at that time. And the circumstances are that, he, as you mentioned, the proximity is extraordinary. It's just a couple days later. In addition to that, what else do you look at for why, whether the proffered reason that the CNL is putting forth is accurate? Well, you look at issues like progressive discipline. Was this person in trouble at work ever? Well, no. I mean, he had no. I've got his personnel file. There's nothing in there reflecting any sort of discipline. Okay. Well, what's the reason he was terminated? And they've given 2 different reasons. They've said, well, it had to do with absences. And then when we produced a text message conversation saying, well, this doesn't add up, then they said, well, actually, it's this coworker. And then, okay, well, you look at the issue with the coworker. Is this a situation where this person had issues with this coworker, where they talked to my client about this coworker saying, hey, employee A has a real problem with you. He says A, B, C, D, and E. What do you have to say about that? No, that didn't happen. They just fired him. I mean, I don't think that there's, and in our view, that's just not how a reasonable employer behaves. If a manager, is sitting there and employee A says, hey, I've got problems with employee B, basically what everyone would do is they'd go talk to employee B and say, hey, what do you have to say about this? They wouldn't just say, well, we believe you. We're just firing employee B then, I guess. And that goes to the issue of pretext, because, what's the real reason? And there's case law that I cited in my objection that says that a court or this commission can consider if the employer's reason is unworthy of credence. I think that's the actual phrase that's used. And in a case where they've issued 2 different rationales for termination, depending on who they end up talking to and at what time, and in a case where the employer's actions really don't make a lot of sense, I think there's evidence that their rationale was unworthy of credence.
But in terms of the July, the second whistleblowing incident, isn't it problematic for you that the employer itself had already sort of blown the whistle on this? They had references to the employees and let them know that, that you need to move your stuff out of this refrigerator.
I'm glad you brought that up, because that's worth discussing. The issue is, and this argument was, as I said in my objection, I don't think it was directly raised by the investigator. Almost mentioned it as an aside at the end. That really goes to whether or not this person is really blowing the whistle at all. But notably, the investigator found that my client had met his prima facie case, which necessarily means there had to have been a finding that he did in fact blow the whistle, that he was a whistleblower. The investigator's report really turns on whether there's a but-for causation issue there. But to get to the heart of your point, the issue is whether or not someone is bringing up a whistleblowing complaint for the purpose of acting, and I've got the exact quote here somewhere. Bear with me just a minute. Basically, that whether they're bringing it up to be in opposition to a particular action. The idea, the fact that they told their employees they're doing it is actually, in our view, irrelevant, and I'll explain why. The bringing attention to in this case was him informing his boss that this was an OSHA violation, which is something the company may not have known. There's no, I mean, it appears that there's no question that they did it, and even if they said to their employees, "Hey, this is what we've done," that doesn't get them out of a whistleblowing, liability. I mean, as I sort of drew an analogy in my objection, I said if a company is dumping chemicals in the Penobscot River, and they say to their employees, "Hey, we're dispensing with this stuff by these means," and an employee jumps up and says, "Hey, that probably violates several DEP regulations. You can't do that." The company doesn't avoid whistleblower liability just by telling them that, yeah, we're doing this. And I don't think there's any case law that says that either. So,
Attorney Black, thank you.
you're welcome.
Following up on that, didn't they fix that violation immediately? Didn't they make notice about the food in the refrigerator and tell people not to put their food there?
Whether they told people, I think just to get at your question, I don't think in terms of fixing the violation, I don't think there's been any evidence that they fixed it. Did they tell people that they're, hey, we're storing this paint in the refrigerator? I don't know whether, I can't remember honestly whether they said, "Oh, you shouldn't store your food in there because of it." But the bottom line is paint was stored in that refrigerator with consumables. I mean, we have a picture of it we submitted to the commission where it's in there with Hershey syrup and whipped cream. It's right in there. And as soon as that's done, that's a violation of OSHA.
If they tend to it immediately, it doesn't serve to cover his inappropriate actions in terms of taking time off and going to the store and sleeping in his car, which is what the allegations are.
I'm sorry, I'm not sure I understand your question. I'm sorry.
The fact that he told the employer about the paint in the refrigerator for the food doesn't give him coverage or excuse to violate other personal policies about attendance. I don't think there's any question that that's just because one blows the whistle does not give one carte blanche to violate employer policies. I don't think there's any question about that. However, there's a serious question as to whether those policies were in fact violated. And the fact is that there's absolutely no paper trail demonstrating, and this gets back to part of the reason why there's no progressive discipline in this case. It's not like there's any written warnings or any documentation saying, "Hey, we found you sleeping in your car. That's unacceptable. This is a warning to you." There's nothing like that. There's nothing documented in this case that really suggests. You keep saying there's nothing documented, but there's a substantial meeting with him addressing all those issues. Is there not?
No, I don't think there was. There was one meeting in April that had to do with specific absences that he had relating to him being gone in the middle of the day. And he went to his manager and he said, those were for chiropractic appointments. And then he produced documentation showing that they were for chiropractic appointments. And then that was it.
Yeah, and that meeting told him he can't go home whenever he wants to, and that he needs advance notice, and that his appointments, well, okay. Seems to me that meeting is a recognition of the problems, and that he's on notice about it. You don't think so?
Well, no, well, I didn't mean to quibble with you. I didn't think that. I'm not sure that was a question, but I'll respond to that. It was that it addressed a very specific issue in our view. It addressed, why are you gone in the middle of the day? And the answer was, I had chiropractic appointments. And then the next day he produced documents showing he has chiropractic appointments. And that was it. I don't think there was any discussion. I don't think there's been any testimony or evidence that there was any discussion about any other issues. It was just that isolated issue about him being gone in the middle of the day. And I will also say this, there's no record since that conversation happened in late April, between then and his termination, that there were any specific absence violations. It's not like there's something in a file saying, hey, on June 5th, you were out in the middle of the day, and you didn't provide us with information. There was no documented issues between when that conversation happened and the actual termination.
In your view, does the employer have the right to make that choice between employees if the employer is faced with that demand?
As I said in my speech, an employer has the right to do it, but if you're looking at things from a pretextual or a causation circumstance, there's no question an employer can just take employee A's word and fire employee B, even though that may be irrational or inappropriate. It's not illegal.
There's no question that they can do that?
They can do it, but you can't. But if someone's blown the whistle 2 days earlier, it's highly suspicious and is evidence that that was a pretextual issue.
Okay, we'll ask the investigator. Thank you.
Any questions for Attorney Black? Okay, seeing none. You'll have about 3 minutes when we come back to you. I apologize, I don't know your name.
Brent Singer.
Brent Singer, okay, Attorney Singer.
My turn?
Your turn.
All right.
You have 10 minutes. Do you want to reserve any of your time?
No.
All right, you're ready, go ahead.
I'm Brent Singer. I'm the attorney here on behalf of the respondent. Emery Story was going to be here, but covering for her today. I got a few things that I think are very important that I want to say, but at risk of responding to a couple of things from Attorney Black right off the bat, I think there is nothing but the timeline here. I mean, when asked, that's essentially what he said. He didn't go at great length. I think the meeting on the 29th or so of April, it turns out they scoured his attendances and there were still some unaccounted for even after the chiropractic visits. And it does, well, as is almost always true, that the complainant alleges facts differently than the employer in this case, but there is something that's undisputed. This past February, the investigator posed 17 written questions to the man identified in her report as coworker, and coworker responded in detail in writing, and the investigator provided coworkers responses to counsel for respondent last February, and I assume the commissioners have that available to them in the file. Coworker explained to the investigator that he had stopped working for respondent back in August of 2023. So we have an unusual situation here where we have about as independent and unbiased a witness as you're going to find in a lot of these cases where he said, or he said, she said. And the coworker verified three things that are, I think, it really in terms of this matter. First, coworker verified that the complainant was a poor worker, came late, left early, had poor attendance, caused coworker to do things that complainant ought to have been doing. Complainant had very bad anger management issues, and complainant made coworkers' life miserable at work. Coworker verified all that, no longer working for respondent. Second, coworker verified that coworker let respondent know, supervisor, not the GM, know that he couldn't work any longer with complainant and was quitting because of the complainant. And that was towards the end of, as you point out, on this timeline, it was about a week or so before GM made the decision to fire complainant. But coworker went to supervisor, so it didn't percolate up to GM yet. In the real world, these things don't happen just like that. So coworker verified that just before general manager decided to fire complainant, general manager in fact talked to coworker and asked coworker point blank whether coworker would be willing to stay if complainant were gone. Coworker verified that he told GM that coworker would stay if complainant were let go. And that's what happened. That's what the investigator found. GM fired complainant so coworker would stay, and because complainant was a bad worker with attendance issues who made the workers around him miserable. Third thing that coworker verified is that complainant's safety concerns were honestly bunk. Coworker verified respondent's account of the rear entrance issue, verified that complainant essentially concocted it as a safety concern because complainant seems too lazy to use the front entrance that other workers had no problem with. And it was complainant himself who improperly removed the railing from out back where workers have been instructed not to use from the get-go for years. Coworker also verified that they were told about the paint in the refrigerator that morning, not to use it for food, and there was even a sign on the fridge. So to summarize, respondent believes that this was a concocted claim from the start. Namely, the supervisor, before complainant brought it up, told employees at a meeting, including complainant, to move food out of the fridge. The investigator is correct that there is no evidence at all that complainant was fired directly or indirectly because he then told supervisor there shouldn't be food in the fridge. I mean, it doesn't make any sense that a company would fire somebody for telling the supervisor that there shouldn't be food in the fridge when the supervisor just told all the employees there shouldn't be food in the fridge. So all the evidence supports the investigator's conclusion that the real reason GM fired complainant was because GM wanted to keep coworker, and complainant was a bad worker with attendance issues who made people around him miserable. If you have any questions, I'll be happy to answer, but I think it speaks for itself.
You said that the supervisor told the employees that morning that they put the paint in, not to put food.
Yeah, and it was a one-off thing. It was very unusual.
It was a surplus of paint that needed to be
It
chilled.
was a special delivery of some special paint that needed to be refrigerated that morning. So they warned the employees, get your food out. But apparently some of the employees didn't, or they probably thought, well, I don't care, my sandwich is airtight in this thing, the cans of paint or whatever.
Yes, good morning.
Good morning.
So I'm looking at the exhibits to Attorney Black's submission. And in particular, I mean, just starting with exhibit 1, the termination letter.
Right.
It looks like it was written in follow-up to this conversation in April, right, where they discussed the absenteeism. And then they say, you know, we had an issue on the 7th, you left early, you didn't come to work on the 8th and the 9th without notice. And so we decided to terminate, basically, right?
Right.
So my question is, I mean, looking at exhibit 2 then,
Right.
I mean, doesn't exhibit 2, isn't he providing notice that, you know, he's got an unexpected framing drywall crew at his house? I'm sorry, it's sideways on my tablet. You know, they had an opening in their schedule, and then it seems like respondent says, if you need to take care of your house stuff, then I guess we'll have to catch up next week, i.e. this is okay.
I guess, well, when my boss, well, I shouldn't speak in the first position here, but when a boss tells the worker, well, I guess, that's not an endorsement of what you just did. Now, you got to remember this is a welding shop. These are not sophisticated HR people. The supervisor who wrote the termination letter whipped it out. From his point of view, attendance was the issue. Certainly at that point, it's what he hung his hat on. It's company had to give him something. That's what they gave him. And there was truth to it. It was verified by coworker. The guy had bad attendance problems. He was out sleeping in the car. He wasn't doing his job and so forth. So, it's true. And then of course, when it goes to the Maine Human Rights Commission, sophisticated HR people get involved and we find out more really what's going on. And it's also understandable in the real world that GM wouldn't want to, you wouldn't want to tell human nature, you wouldn't want to tell complainant that coworker is the one who got you fired. I mean, that's a hard thing to say to somebody. So again, at that point in time, they didn't go into that. So,
Right.
and so here we are.
Yeah, I mean, I get your point about the sophisticated HR people. I guess the commission standard is an even chance at trial, right? And so don't you think that based on these text messages, it's possible that a judge or jury could believe that they said this is okay? You know,
It's possible. Well, I think they have a legal hurdle. I can argue legal technicalities here, but they have a legal hurdle as to whether or not the fridge complaint is even whistleblowing activity, and that could go away before there's ever even a trial.
Understood.
If there is a trial, of course, it's possible. But I don't think that's the standard that the investigator is tasked with doing. My understanding is that one of the reasons why the commission has investigators is to go out there and talk to people and make credibility determinations when it's clear to the investigator. Now, if it's, I don't know, but here I think, I don't want to put words into the investigator's mouth, but I think she thought it was clear and that there's no evidence that it was his complaint about the fridge. And so it's, whatever you want to phrase it, more likely than not, that's how a jury would someday decide it as well, especially if a coworker was testifying.
And it's your position that the GM didn't even know about the whistleblower complaint, right?
Correct.
Okay, the supervisor knew.
I'm not, I suspect the supervisor thought of it as just, what are you telling me? I just told you that, don't put stuff in the fridge. Now you're complaining to me about this. I'm not sure a supervisor even conceptualized it as, oh, this is a OSHA complaint or something like that.
Right. So Attorney Black argues that the supervisor's knowledge should be imputed to the general manager. Do you have a position on that? I think this is
right. Well, I don't think the supervisor has any. There's no evidence that supervisors' animosity toward complainant stemmed from the complaint about the refrigerator. And that's what I think the investigator keeps getting back to, is that when all the smoke clears, there is nothing but this timeline. And so even if the supervisor just, apart from the refrigerator thing, thought complainant was a bad worker and had attendance problem and was tired of it, and sort of went to general manager and said, geez, we're having more problems with this guy. And then general manager then talks to coworker, and then general manager decides to fire a complainant and keep coworker. So.
All right, thank you.
Mm-hmm.
Attorney Black wants us to consider the fact that he claims there's an inconsistency in stating the grounds when he's before unemployment and when he's before in his complaint to the commission. Do you have a response to that?
No, I looked through the file. I think the unemployment stuff was pretty early on, as it typically is. And in the end, the employer, there was some mess up with notice of of a hearing, second level hearing, because he was granted benefits on the first go round, the employer was going to appeal. There was some mess up on getting notice of that hearing date. And when that came up, the employer just said, "I'll forget it." So I don't think there's.
So there never was a hearing?
No developed presentation about this.
Any other questions for responding attorney? All right, have about 4 minutes and we come back.
I'd be amazed if I come back, but thank you. Might not be able to get rid of me now.
Attorney Black, you have 3 minutes.
Thank you. Just wanted to rebut a couple things that counsel said. There's an indication that there's nothing but the timeline. We disagree with that. At the end of my opening, I rattled off 6 different things that the record showed. You know, we've got different reasons, CNLs saying different things to different people at different times. We've got the rationales that have been put out there have, in our view, been debunked through text messages and through other evidence. The supervisor, I mean, you know, with respect to what the supervisor did, I mean, my client specifically used the word OSHA when he brought it up to the supervisor. He said, you know, you can't put it in there when there's other food in there. To counsel's point about, you know, the text message response not being an endorsement of having days off. If an employee says to a boss, "Hey, can I have Monday off?" and the boss's response is, "I guess," I don't think any person would think that that is in any way a denial of that request. There's nothing in that text message that would give any person any sort of notice that there was any sort of denial of that request. It came up several times that my client was a poor worker. There's no documented evidence of this. If my client were such a terrible employee, my client had done half of the things he was accused of doing by this coworker, then surely there'd be something in the file showing that he's doing all of these terrible things. He wouldn't have made it 5 years, but there's nothing there. You know, aside from this isolated absence issue that came up with his doctor's appointments in April, they didn't even talk to him about it stuff. My client had absolutely no idea that anyone was complaining about any of these issues. You know, with respect to the argument that you know, well, they didn't want to tell him that this coworker was the one that got you fired. Well, that doesn't explain why they told the Maine Department of Labor the same thing that was in the termination letter, and that was months after the termination. And I don't have that document right in front of me, but it was attached as, I think, Exhibit 1 to the Maine Human Rights Commission reply that we sent some time ago. I don't think it went to a hearing, but obviously when something goes before when there's any claim made, the employer has to respond in writing about what the reason is. And coworker did not come up. It was only about the absences. It was basically a repeat of the argument in the termination letter. It wasn't until he produced the text message and this other stuff with his charge of discrimination that suddenly it became about a coworker. It was the first time that argument was ever raised. Finally, it's also, again, worth noting that this coworker put in his notice on June 28th. And if this coworker resigning, saying, "I can't take this guy anymore, I'm putting in my 2 weeks," if that was the reason, then why wasn't my client terminated then? June 28th, June 29th, 30th,
That's your
1st,
time, Attorney
3rd.
Black.
Yep, thank you.
Any questions for complainants counsel? Julie, Commissioner O'Brien.
Thanks. I'm trying to find it in here, but are you, because I thought I saw somewhere in these 25 pages that he brought in showing his appointments and they didn't coincide?
He did. Oh.
That there were still several unaccounted for absences.
I think there's a disagreement about that. I'm not saying that there isn't, that there might have, I mean, I think that the vast majority of them might have been covered by the doctor's appointments. To the extent there were others that were not, that was not really, I don't think there's a lot of evidence that remained some sort of issue. It's not like he received a written warning saying, hey, we've looked at all these appointments and, we couldn't match up January 5th, 6th, and 10th or something, and we're warning you for this. I don't think there was a whole lot of further scrutiny given to that. I just don't think there's a lot of evidence, at least at this stage, that would show that there were other appointments that somehow didn't get matched up. I just don't think that a lot of that was really developed as the case went on. But I think the vast majority of them were chiropractic appointments, which he brought in documentation showing that was the case.
Okay,
Yeah, go ahead.
I keep going back to the April 29th meeting. The supervisor spoke with complainant about his absenteeism, and he agreed to be present from 7 to 3:30 and to provide advance notice. And then the next month, it did improve, and that the next 2 months, it did improve. So are you saying that there was no documentation of that meeting, or that it didn't happen, or?
To be clear, the April meeting did happen. There's no question that it did happen. Both sides agree that it happened. But to the extent that there was some sort of, I don't believe there's any document that reduces that meeting to some sort of warning or that documents, hey, we talked about A, B, and C. You'll agree that you've agreed to improve, here in areas of X, Y, and Z. I also don't think that my client would agree that there was really that he even considered it a verbal warning, because from my client's perspective, I think what he said in the Issues and Resolutions Conference when he was asked about this was that there's no question absences came up. They said, hey, we've got you being out on certain days, and why were you not here? He brought in the chiropractic appointments schedule, and that was the end of it from his perspective. He really didn't hear anything further on that.
Okay, thank you.
Well,
Any other questions for Attorney Black? Seeing none, Attorney Singer, you have 4 minutes if there's anything you'd like to add. Okay.
No.
Any other questions for Respondents Council? Okay. Seeing none, thank you both. We will next hear from Investigator Leva, who is the investigator assigned to this case.
Good morning, everybody. I hope you can hear me okay. Excuse me. For me, this case was a little bit difficult to initially resolve. After actually conducting the IRC conference, being with both parties, I wasn't quite sure which side I believed more, honestly. Both sides seemed to have I was a little bit concerned of the veracity of both sides' claims. So what I really focused on was speaking to that coworker. The coworker, especially considering that he no longer worked there, continued to work there for a few years after Mr. Nelson was let go. He seemed a much more reliable source to me for information. And while I agree with Attorney Black that it may not have been the most prudent decision to fire somebody based on somebody else's account, I don't think that that's tied in any way to the report that he made about the refrigerator. Again, as it's been stated, the refrigerator issue was already brought up, and the employer had already addressed it. So I didn't think that report would have contributed that much to the decision to let him go in any manner. So I hope that answers most of those questions. It may not, but I'm happy to answer anything else.
Questions for the investigator, Commissioner Davis?
So you did talk to the coworker yourself?
I did, yes.
Thank you.
Commissioner Douglas?
Yeah, so I guess I'm just wondering, based on your investigation and talking to everybody, what is your best impression as to why complainant was actually fired?
I'm sorry, the question was why he was let go, correct?
Yeah, based on your investigation
Yeah.
and talking to everybody in the case, why do you say in your report that, the whistleblowing doesn't appear to be the but-for reason why he was let go? And I'm wondering, what do you think that reason was, if there was one?
I think the reason genuinely was that there was another worker that employer wanted to retain, and that what occurred as far as the whistleblowing goes Yes, fairly circumstantial, but I don't think that that ended up being the cause. I think the cause was just that there was another coworker that the respondent wanted to keep more.
All right, thank you.
Any other questions for the investigator? Seeing none, thank you, Newford. All right, so we've heard from the parties and the investigator. At this time, we'd be looking for a motion. There's one proposed finding.
I'll move that we find that there's no reasonable grounds to believe that respondent retaliated unlawfully against complainant for WPA or MHRA protected activity.
Second.
And the complaint should be dismissed.
All right, it's been moved and seconded. Any discussion?
I'm impressed with the multiple accounts of the coworker. The general manager talked to the coworker, and our investigator talked to the coworker, and there's no allegations of anything untoward in that conflict or any allegation that the coworker's complaints were not valid. It's pretty clear to me that the complaint, the OSHA complaint about the paint is not the reason. And I think it's the investigator's conclusion that the discharge is not related to those activities is well supported. I mean, it was that same morning that they came in and said, hey, we got this emergency with this paint's got to be chilled, get your food out of it. And the complainant is trying to capitalize on that, saying, oh, you can't fire me because I'm going to say that that's an OSHA violation. That's the reason for my motion.
Yeah, I'll just add to that. I think that the complainant did a really good job creating an issue with respect to the stated reason for termination. As I sit here, I don't believe that complainant was terminated for his absenteeism, which then brings it into sort of that gray realm where why was he terminated, right? I think where this claim falls short is on the whistleblower side of it. As Commissioner David said, you know, they addressed it the same day. I mean, and there was a little kerfuffle earlier. You know, the investigator's report says that the respondent actually told the employees to move their food and so on to a different refrigerator. So basically, to the extent there was an OSHA violation or et cetera, was addressed that day. So it's hard to imagine he was terminated for that. So I think that, it's unfortunate that the termination letter clearly does not reflect the true reason for his termination. But I also don't think that that there's a valid whistleblower claim here. So I'll be joining it.
Any further discussion? None. If the motion is to find no reasonable grounds, if you are in agreement with that motion, you will vote yes. Commissioner David?
Yes.
Commissioner O'Brien?
Yes.
Commissioner Walker?
Yes.
Commissioner Douglas?
Yes.
All on the commissioner who has recused herself. Great, thank you. So the findings are no reasonable grounds. We appreciate everyone's participation, and the commission will send a letter to the parties and council confirming the results of the hearings. Could we take 5 minutes?
Sure. We'll be in recess for
I'm gonna pin Nicole Chomiak.
We all set?
All present and accounted for.
All present and accounted. So the next case is Billy Sue Ham versus Pratt and Whitney, E220125. Correct me, Kid, I mean, we have a split two recommendations for no reasonable grounds and one for reasonable grounds. Do we take the no reasonable grounds first and hear from complainant?
I think that's up to you. I know that last time you had asked Ms. Ham to come forward first, and she's right here. So.
Okay, this is Ms. Ham, the complainant?
Yes,
Okay, you're here. We'll hear from you.
I'm pretty much rolling with the
Yep.
same as before. I'll reserve whatever for the end. It's been a long road to get here. I believe firmly that there's a lot more that will show the retaliation as well as the sexual discrimination. However, I will move forward with whatever the recommendations today. Thank you.
Even less time than the last time, 20 seconds.
Which is hard to believe, honestly.
I thought you set a record last time, and I do want to thank the parties for their flexibility with our tech difficulties last time, so thank you for being patient. I believe I figured out the issue now, that won't happen again. All right, so you'll have 9 minutes and 40 seconds. Any questions for Ms. Ham?
Oh, sorry.
Okay, seeing none. Attorney Chomiak, you have 10 minutes.
Thank you, and good morning, everybody. I'm only here to really address the disability discrimination. Again, we adopt or agree with the findings on the sexual harassment, and retaliation. And I should be brief as well, and I'll reserve whatever time is left, but I intend to be very brief. The investigator found that there was no prima facie case of disability discrimination, and that Pratt did not have a legitimate non-discriminatory reason for an adverse action. And those are the two areas I just want to focus on, because I think it's pretty clear that complainant Ms. Ham cannot establish a prima facie case of disability discrimination. And that is because she can't show that she was qualified for the position at that time. So we submitted evidence, and complainant's evidence also supports it, that during this time period before Ms. Ham was asked to participate in a psychological evaluation, Ms. Ham was struggling. And the evidence shows that through email, and it was submitted to the investigator, that Ms. Ham said that she's so stressed, she's scrapped parts, and she was unable to do her job. She asked for time off. She said things like, how much vacation am I going through so I can take time off to begin my healing? She also referred to herself as an anxious wreck, emotionally destroyed. She agreed she needed a leave of absence, but I guess her doctor wouldn't approve it. She said she was beyond overwhelmed, and she was afraid to come to work. So those own statements through emails to HR show that, in especially the statement that she, quote, is unable to do her job, shows that she was not qualified for the position at that time when Pratt asked her to submit to the psychological evaluation in order to continue working. And again, that was all submitted. Pratt reasonably believed that she could not perform her job based on her statements and her actions too. There were some actions where she slammed her fists on the manager's desk, and she said things like, I can't go in that place until I get my head right or head straight. So again, I think the evidence clearly shows that she was not qualified for the position and therefore cannot establish a prima facie case. If she could establish a prima facie case, again, the next step goes to Pratt's legitimate non-discriminatory reasons, and the same evidence and the same supports Pratt's legitimate non-discriminatory reason for asking her to submit to the evaluation. Again, the slamming of the fist, erratic behavior, the statement that she could not do her job. So the burden now then would shift. So again, Pratt satisfied the legitimate non-discriminatory reason. The burden would then shift to show that disability discrimination was the real reason for Pratt's action, and there is absolutely no evidence of that. In fact, I'm going to call the commission's attention to footnote 6 of the investigator's report, and the investigator suggests that or states that the record shows that, and I'll read it. It's the second paragraph. Even if respondent had made the argument that its adverse action was based on complainant's potential for violence, such reasons would have been pretextual. While the record shows that complainant engaged in unprofessional and even rude communications with HR and manager, there is no evidence that her attitude rose to a violent level. And again, the psychological evaluation agreed with that. However, nobody knows that until the psychological evaluation is done. But it's the next sentence where it says, furthermore, if respondent believed that complainant was insubordinate and violating respondent's workplace professionalism policies, then it should have terminated her employment for that reason. And again, I think that shows the exact opposite of a reason for discrimination or a discriminatory motive. Pratt didn't terminate her for acting the way she was acting. It instead tried to work with her in order to get her in a place where she was able to return to work. So again, I think the evidence is pretty clear. No prima facie case. If there is a prima facie case, Pratt had a legitimate non-discriminatory reason, and then the burden shifts to complainant, Ms. Ham, to show that it was really discriminatory. Going to the fitness for duty examination, I know there were some questions about that. Again, you don't know that someone is nonviolent until you have the psychological evaluation. And even the psychological evaluation, the psychologist recommended that she take 6 weeks off of work. She said that, or he said that he recommended a mental health program and said that Ms. Ham could perform her job when stable. And again, recommended 6 weeks off and a mental health program, and then another fitness for duty exam before she returns to work. You can't know that somebody is nonviolent and able to return to work until the psychological evaluation was performed. So again, take a little bit of issue with thinking because the psychologist found that she was not violent, nobody knew that until after the evaluation took place. So for those reasons, again, we think that the disability discrimination claim is not substantiated and the finding should be no probable cause.
You'll have about 4.5 minutes when we come back to you. Any questions for respondents, counsel? Commissioner Sanders.
Thank you, Attorney Choliak. It's Megan Sanders. Curious about the period of leave that the complainant took at the direction of the employer. Did the employer co-designate that leave as either ADA qualifying or FML qualifying at the time?
I don't know if it was necessarily coded as that, but her job was held open. So in other words, there was no time limit of when she was going to return. There was no deadlines or anything like that. They were seeing her as on a leave of absence to be determined when she could return to work. If the process took longer than the FMLA allotted, that would have been fine.
And I noticed too, in the investigator's report, that seemingly there's no evidence that your client actually has fitness for duty policies in place, so that at any given point in time, right, that the workforce can be educated about what that process looks like. Am I mistaken? Does your client have those policies in place?
There's not a specific fitness for duty like you would see, let's say, for like a workers' comp evaluation or to perform a specific duty of the job. The concern here was that there was a reasonable belief that she was not able to perform her job and that she was either possibly dangerous to herself or dangerous to others in the facility. They also were concerned and had a reasonable belief that she could not perform her job. And I think that is definitely supported by her own statements that said, I can't do my job, I'm unable to work, and I scrapped some parts. So I think it's a legitimate reason. It's not a far-fetched, again, when Ms. Ham herself had said those words.
Thank you. And last question, with this leave, this period of leave that was directed by the employer, why did they not pay for counseling that the complainant participated in?
I don't know the answer to that. I think they thought that her health insurance would take care of it, but I do not know the answer of why it was not paid for that specific.
Is there any conversation between your client and the complainant about trying to assess what her out-of-pocket costs might have looked like and then reimburse her for those funds expended?
I'm not aware of any conversations on behalf of Pratt asking her. If complainant knows, I would defer to her if there was any type of communications, but I'm not aware that there was an outreaching by Pratt saying, we're going to pay your bills, submit them.
Do you know, is that part of your client's practice with respect to its fitness for duty workflow or sort of implicit policy that it follows?
Is that their practice to pay for the bills? Is that what you're suggesting? I mean, it would depend on the situation. For example, if it's a workers' compensation situation, then obviously that's dealt through the workers' comp and that's paid for. This isn't a situation that arises very frequently. The mental health of one of the employees and acting the way it is not something that they are, dealing with on a regular basis. So I don't know the answer to that. I certainly think if it was broached, it certainly would have been a reasonable discussion to discuss how to pay for those bills.
Thank you.
Following up on that, I had that same question too about the cost. Could that not be construed as an obligation of the company to reasonably accommodate the disability that they perceive to be there in terms of her stability and mental health issues?
I mean, if you're looking, I see what you're saying because they're requiring it as to go through this evaluation to come back. My understanding is that the evaluation was paid for, but the actual therapy or the visits after, and Ms. Ham can correct me if that's not true, but the psychological evaluation itself was paid for by Pratt. The recommendation by the psychologist to have additional therapy sessions is what the issue is that is not paid for. I think, and again, Ms. Ham may correct me on that, but I think if you're looking at like an ADA standard or an FMLA standard, it isn't, if an employee comes to an employer and says, I can't work because I need time off to deal with my mental health, the employer doesn't have any obligation to pay for that. They just have the obligation to provide the time off and protect the job. So the actual evaluation, I'm sorry?
Unpaid time off.
Exactly. FMLA is unpaid time off.
My second question is it seems, and I can't put my finger on it right at the moment, but the complainant says that she emailed May 11th, May 19th, and June 8th, saying I've done everything I can do, and that there's no response from the company.
There was a period of time when she was communicating. There was only one HR person that Ms. Ham would agree to communicate, and that was the last person, Wes Downing. The other individuals through HR, Ms. Ham specifically requested that they be taken off her case. There was a period of time when Mr. Downing was out of the office and did not respond, and that could be that week that you're referring to. But he did respond frequently. There were many emails that Ms. Ham sent to Mr. Downing, sometimes multiple times, sometimes several times during the night. But Mr. Downing did respond. Sometimes it might take him a couple of days, but he did respond.
Well, this is a month. Do you know why there was no response?
In the specific to that May email?
We're being asked to conclude that that's indicative of the employer's decision to terminate it. And we're not
the employer did not terminate it. Ms. Ham voluntarily resigned her employment. She decided that she could not return back. It is a constructive discharge claim, yes. But at this point too, there was efforts to try to get Ms. Ham to go through the process that the psychologist set forth of the additional counseling and then transition back to work. So that was Pratt's intention, was to transition her back to work. She then decided that she did not or could not do that.
Remind me, if you would, why the hostile environment and the sexual hostility claims go away? It's because they're time barred, are it? Because that behavior sounds horrendous.
Well, so she reported this conduct after the alleged offender had left the company, and she actually didn't report it. One of the managers noticed that Ms. Ham was distraught. So they asked her what was wrong. She said what had happened. The manager reported the conduct. Initially, Ms. Ham said she wanted to keep it quiet. She did not want to go forward. It took 2 weeks before she would agree to even speak to HR about the incident. At that point, they investigated. They determined that the badge swipes, so Pratt is a secure facility. You have to swipe a badge to get into the location. Ms. Ham described the location that she said that this incident took place. They compared the badge, she didn't know the date. She gave like a range, I believe it was like a 2-month range. And they compared all the badge swipes between the offender and Ms. Ham, and there was none that correlated. And again, at this point too, the offender had already left the company. He had resigned from Pratt. So there was nothing that Pratt could do to terminate an employment.
Seems as though you ought to make an election there, as the reason is that the perpetrator is gone, and so we can't discipline them, and we're responding as fast as we can, and the perpetrator is gone. Instead of throwing in this question about badge swipes and maybe factually we're casting some doubt on it.
I don't think they were recasting. They were very encouraging and actually told Ms. Ham or encouraged Ms. Ham to report the incident to the police so that they could also be outside, separate from Pratt. Because again, when the offender is no longer part of a Pratt employee, they can't do anything to discipline him. So at this point, they were encouraging Ms. Ham to go through to the police to take whatever actions necessary against this individual.
Do you agree with that indication in footnote 6, which I noted also, that the investigator is saying maybe they could have terminated her for that behavior on the right then and there? Do you agree that they could have?
I agree they could. I agree they could have, but I think that's why it shows their motive not to discriminate against her, because they clearly thought that Ms. Ham needed some help. She was not acting rational at the time, and they felt that they could get her the help that she needed and then return her back to work.
Thank you.
Commissioner O'Brien.
Thank you. In reading this case previously, I was struck, and you just spoke about it. It appears, and you correct me if I'm wrong, that the badge swipe situation and saying that if they didn't correlate, it appears that your client is inferring that it may not have happened.
I don't think they're inferring that it may not have happened. I think there could have been some different results if everything was matched up. For example, if they did badge swipes and they realized that, this was an ongoing, they found them together, several times in the same room together, then maybe they could get witnesses to collaborate, or they could find out, they could pin it down to a specific time and maybe take it a step further. They have a duty and an obligation to investigate. That's clear under, our laws require us, when there's a report of sexual harassment, to investigate. That's how they investigated it. And, there's no pre-knowledge or any pre-desire to find substantiated or unsubstantiated. They wanted to find out what happened. And I think that's their obligation to do so, and they followed their obligation.
Okay, thanks.
Any other questions for Respondents' Council? None. You'll have about 4 minutes when we come back to you. Ms. Ham, you have 9 minutes and 40 seconds if there's anything else you'd like to add.
When the badge swipe is called into play, there is such a thing called badge writing. They write each other's badges. One person swipes, the other person runs through before the door closes. There's also 2 doorways to that room. That gentleman laughed at me and told me he knew I was alone. All of this stems from, and if you read all of those emails and you trace them all back to HR, not one time that I went to them helping out. Not one time. As far as this 30-day, I cannot tell you how many people have come to me and said that Pratt has still not asked them about the very first incident that was brought up. So people have not been interviewed. There has been no done my due diligence by Pratt and Whitney. People still have not been spoken to. They can corroborate my truth and everything in those papers. That's all I have to say.
Any questions?
Hold on, sorry.
Commissioner O'Brien.
Yes, can you tell us about did your insurance cover it? How did that work? Out of cost?
There was so much back and forth with the out of cost. I was told I couldn't use the employee assistant program. Then I was told I could use the assistant program. Then I was told I wasn't. The only thing I knew for a fact was I paid for the initial fitness, but I have to pay for the second one to come back in.
Okay, and did you make a police report?
I did, because I was asked to, so that Pratt and Whitney would have a reason to not hire him. It wasn't for me, it was for Pratt and Whitney's HR. And I did.
And he will come, I'm sure of it, for depositions court, any of it. He's not gonna get in any trouble
Oh,
because
so
they won't back it up
So it has not been investigated yet through.
by the police department.
Right.
It's a simple assault. They have a police officer that's their security guard. They won't do anything. North Berwick police officer works their security. It's simple assault. They won't do anything. So, I mean, because if they investigate, the Brett has to give the info and they're not going to.
Thank you.
Any other questions for Ms. Ham?
Go.
All right, Attorney Chomiak, you have 4 minutes and 30 seconds if there's anything else you'd like to add.
Just to address those two brief parts, Pratt does have a security officer, but that's not what they instructed Ms. Ham to do. It was to report it to the police, and the police have their own investigation processes that Pratt does not influence or have any say over. And it was not the suggestion to report the incident to the police had nothing to do with Pratt to rehire. This was, again, and it's documented in the emails. There was actually an email from HR initially on when they were discussing the incident where Ms. Provencher from Pratt instructed Ms. Ham to go to the police to report this assault, and actually strongly encouraged her to do so. And again, that had nothing to do with Pratt's reasons to rehire. They don't have to have a police report on file to not rehire an employee. And the same thing about the investigation. The employee was no longer employed. The results of the investigation would not have changed what Pratt was able to do, which would be to terminate that person's employment. He was no longer employed. It is documented that he was accused of this assault. There's nothing more to investigate on the part of Pratt because, again, the employee is no longer there. They couldn't even speak to the employee because he is no longer a Pratt employee. So those are the only two things that I'd like to say.
Questions for respondents, counsel? All right, seeing none, thank you. We've heard from the parties, and next we'll hear from Colin Hurd, who investigated.
Good morning, commissioners. My name is Colin Hurd. As you know, I was an investigator on this case. So just a few things, I guess. First of all, I just wanted to say I don't believe that there was any indication from complainant's behavior that posed a threat to herself or others. I understand that that's what respondent is trying to argue, but based on what I saw, that seemed to be a little bit overblown. As you saw in the report, the complainant was eventually diagnosed with PTSD, and this is all following very shortly after the sexual assault that she experienced. So I think, and this is personal opinion, but I think the troubling behavior was probably a demonstration of the symptoms of PTSD and after, like I said, going through the sexual assault at work. That be as it may, having read all the emails, exchanges between complainant and HR, as well as some of the text messages between her and some of her coworkers, some of her interactions with people were definitely rough and definitely even rude, unacceptable and unprofessional. The emails that I read did not paint her in a very good light, but that was also before I had interviewed her and spoken to her. However, none of those emails were violent or necessarily seemed to pose any threat. They were all about what she was personally experiencing. And those are detailed, as the respondent pointed out in footnote 6. As I learned through my interview with the complainant, a lot of this behavior towards HR especially was based on her frustration with the respondent's previous actions regarding her request to move to a new shift in response to what happened, but also with some previous experiences with HR. So she had a history with this particular person who's labeled HR1 in the report over some of the other incidences that are brought up but did not pass the time bar issue. I don't think that she liked HR1. I don't think that they got along very well. I don't think she believed that HR1 was going to act in her best interest. So that led to her belief that they were not listening to her regarding her request to change shifts. And this is in, I guess, response to the sexual assault. She wanted to move to a different shift and be with certain people and not with others. And all this centered around the supervisor for the first shift. I forgot the pseudonym that I gave him, but he's mentioned in the report. And she also had a history with him, and that's explained in the report as well, but I can answer questions about specifics of that. Ultimately, as you saw in the conclusion of the report, I think that respondent would have had more justification than simply discharging the complainant for insubordination, but they put her out of work and sent her to a doctor for a psych evaluation instead. That decision, as evidenced in the email, which is in the report from HR2, was based on their perception that she had a mental health disability or mental health issues. In the submission of disagreement, respondent invoked the direct threat defense, which looking back, I think is something I should have analyzed in the report and I did not. And I'm happy to go over I have it up here somewhere, I can go over the exact requirements of that. But I think that argument still fails. Notably, the direct defense requires that someone pose a significant risk to health and safety, which I don't think that complainant necessarily did. Like I said, her emails were insubordinate, and there is the incident that signs her fist on the table. I think out of frustration that they weren't, she didn't feel like they were listening to her. But I think it's also important to point out that, and we cite this case for our direct defense analysis normally. It's Maine Human Rights Commission v. Canadian Pacific Limited, 1983 case that says an employer cannot deny an applicant an equal opportunity to obtain gainful employment on the mere possibility that a physical disability might endanger health or safety. So as you saw in my report and in footnote 6, I think that the idea that complainant posed a danger was dubious, and the respondent's justification was just based on a mere possibility that she could pose a threat. As you saw, the psychologist ultimately recommended that she was not a threat, and recommended that she participate in an outpatient mental health program, receive counseling services, and undergo a psychiatric evaluation that should be about 4 to 6 weeks. And it turned out the program that she ended up going through was about 4 to 6 weeks. She completed those requirements. And as one of the commissioners brought up in the questioning process, there wasn't any evidence that respondent actually engaged in an interactive process with her after that point. She reached out, I believe it was in May, saying, like, I've done everything, what do I need to do next? And there wasn't really much of a response to that. And if there was, it wasn't provided to me. That failure to engage seems to me to deny complainant's opportunity to maintain gainful employment with respondent. So that's why I think that the direct defense would fail in this case. I'm happy to answer any questions.
Questions for Colin? Thank you. Oh, yes, Commissioner David.
There's no response to those emails in May 11th, May 19th, and June 8th.
Right, not that were provided to me. So as far as the factual record.
Well, I don't think counsel doesn't argue that there were any responses that you don't have.
Correct.
That seems to me significant. I was prepared to say that asking for the evaluation was appropriate, that there was enough work-related concern about her behaviors to have the evaluation, but then they abandoned her. Is that your position? That was not, that can't be reasonably construed as working on a reasonable accommodation, because they're not paying for anything and they're not helping her with any appointments, right?
Yes, I do.
And does she complete the psychiatric component there? Does she ever get that appointment?
The final.
Yeah.
Not that. Again, that wasn't provided to me, so not that I'm aware of. So that there is there. No, I'm not sure, but there is evidence she was reaching out to them asking for help with that. And there was no response.
Complicated case, Colin.
Yeah.
Yeah. Thank you.
Thank you, Colin. All right, we've heard from the parties and the investigator. At this time, we'd be looking for a motion. There are 3 proposed findings. You can take them separately, take them together, take some of them together and some of them separately, however you'd like to break it up.
Well, I will try to take them together. Everybody okay? That there are no reasonable grounds to believe that Pratt & Whitney discriminated on the basis of sex. That there are no reasonable grounds to believe that Pratt & Whitney retaliated for engaging in MHRA or WPA protected activity, and those claims should be dismissed. But there are reasonable grounds to believe that Pratt and Whitney discriminated against the complainant on the basis of disability, and conciliation should be attempted.
So to uphold all of the recommended findings?
Yeah.
Okay.
Could I have just said that?
But I appreciate you going through all of
She
that.
did.
Thanks.
All right, so moved. Do I have a second?
Second.
Moved and seconded. Is there any discussion?
Well, I was troubled by the third one, as I say, I read it a couple of times. I thought the presentation by respondent was well written. And I do think that asking for the investigation was not inappropriate. I think it was work related. And our investigators focuses on that, the asking of it and the violation of that provision that says you can't ask for it. That's the reason to say it was discrimination. The reason I'm going to vote for them for saying that there was is because they abandon her after knowing, send her off for the investigation, and they get the results, but they're not continuing to work with her. They're just casting her loose. And that doesn't seem to me to be recognizing the results of the evaluation, the problems he had, the PTSD, which they're on the hook for, in it's their shop that exposed her to that violence, and they ought to recognize that, even if it's time barred, even if the other employees don't.
Any other discussion? All right, seeing none, the motion is to find no reasonable grounds on sex discrimination or retaliation, and reasonable grounds on disability discrimination. If you vote in agreement, if you are in agreement, you will vote yes. Commissioner David?
Yes.
Commissioner O'Brien?
Yes.
Commissioner Douglas?
Yes.
Commissioner Walker?
Yes.
Commissioner Sanders?
Yes.
All right, so the findings are no reasonable grounds on the first two recommended findings and reasonable grounds on the last recommended finding. We appreciate everybody's participation, and the commission will send a letter to the parties and council explaining what will happen next. All right, thank you very much.
I apologize. I'm Patrick Meller. I'm the attorney for the respondent, Working Good Racing, and I don't know what the protocol is when I'm requesting a time accommodation, which I should have requested sooner. I have a client that's meeting with a physician at 11:30, and he's requested my attendance. It's in Augusta.
Your case is next.
Oh, it is next.
Walton versus Working
Wonderful.
Good Racing.
I apologize. I saw another one on there. I mean,
No, that case was withdrawn at the beginning of the.
okay. Wonderful. Thank you.
Yep.
So we are up to Walton versus Wicked Good Vintage Racing, PA 230038. And that is a recommendation of no reasonable grounds, so we'll hear from complainants.
And I apologize, everybody. I should have said this at the beginning of the hearing and I forgot. Please do not use the names of third parties or entities that are not parties to the case. Those individuals and entities have been given pseudonyms in the investigator's report, so please use those pseudonyms instead of the names. All right, Mr. Walton, are you with us? Mr. Walton, you're muted right now.
Says he's muted at the bottom.
Can you hear me?
Yes.
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 I'm not techno savvy and the camera on this laptop doesn't work.
Okay, we can hear you just fine. You know, no need to shout. You have.
That's part of my behavior, so
Okay.
it is what
We
it
can
is.
hear you just fine.
Thank
You
you.
have 10 minutes. Would you like to save any of your time?
I sent a letter in response to your most recent, you sent me an investigative report.
Yep.
I will follow up after I hear what you folks have to say.
But this is your opportunity to present your side to the commissioners?
Well, I think I'd already done that with all the evidence that I sent, but I've never spoken to anybody that has told me anything about this case. I've been pretty much left to my own endeavors down here in Rhode Island in regards to all of this.
In the hearing notice that was sent to you with the investigator's report, there were
Yes.
instructions on, you submitted your statement of disagreement.
That is true.
Yep, so this is your opportunity to explain your disagreement to the commissioners.
All right. Well, frankly, I still am not sure why any of this happened, other than the fact that somebody, you can't use names here. The original complaint in this was wrecked by a fellow competitor at Lee USA Speedway, and I was right down below them, but never made contact with either car. On returning to the pits, I was physically threatened by one of the guys that was wrecked. The other one was parked next to me. His whole family was intimidating. I packed up and left the racetrack. A few days later, I contacted the fellow that was wrecked, and he was the only one of 3 race directors at the racetrack that day, and he was the one that was wrecked. Thought it was me, and then when I talked to him on the phone and told him that there was a video out that totally exonerated me from any contact with him, he said, "Well, I'm not watching any videos," and threatened me again. And that was pretty much the end of the conversations that I had with them. They sent me they had 3 race directors for that particular group. They sent me a certified letter saying that I was banned from further competition. I sent the commission hold on a minute, let me get it. I sent the commission a copy of a letter that I had sent to Wicked. I'm trying to find all my stuff. Anyway, the ban that was placed on me by the 3 directors, there's no rules that allow for that. I sent a copy of the outlaw rules for track procedure to the Human Rights Commission as well. And you can see clearly that there's no place in there for any race director to take any action other than what would occur on a race day. I then sent a letter to to Wicked notifying them. Excuse me while I find this other document. I sent them notice that in fact what they were doing was breaking their own rules. And you have a copy of that as well. The letter I sent them stated that outlaw rules did not empower race directors taking action beyond a specific event. And then they failed to provide due process complaint as prescribed in the duties of the board of directors, which I sent you folks. The board of directors allows for action to be taken if a letter is sent to them within 30 days of an incident. That never happened. And what's more, the letter that I sent in regards to filing a complaint for illegal procedures on the part of the club, they then sent a letter telling me that the board had a meeting and they had agreed that what the race directors had done was okay. And at that point, I realized that the club was only about one thing. They were taking care of their own. They didn't care that I had done nothing. They had somebody that had filed a complaint and they were good enough with that. And then we started this procedure here and noticed that there was a note in your investigative report that stated that I hadn't mentioned anything in regards to a discrimination complaint until late in the process. And I can't disagree with that. I never at any time notified the organization. That's what I thought, because by then I had realized that the organization didn't care about rules or right or anything else. For for whatever the reason was, which the only thing I could do was determine by deduction that the only thing left, they had no cause, so the only thing they left was to discriminate against a disabled veteran. In the end, that's how I came to that conclusion. There was nothing else. I'll reserve the rest of my time. Thank you.
Great, you'll have about 4.5 minutes left when we come back to you. Any questions for Mr. Walton? Commissioner Douglas and then Commissioner O'Brien.
She's senior.
Oh, you raised your hand first.
You were
Okay.
first.
I'm not sure how you're doing it. Don't want to be disrespectful.
Keep it static.
Yeah. Mr. Welton, good morning.
Morning.
Yeah, so I appreciate the tale that you just told us. And I'm sorry you're not able to race in this division that you want to race in. So what we're trying to decide here is whether or not you've been the victim of unlawful discrimination. And I just said that you've sort of deduced that you've been discriminated against because you're a disabled vet. And I'm just wondering, I want to give you the opportunity to state any other reasons why you feel you've been discriminated against on this basis. I mean, I get all your points about the rules and there's no rule against aggressive driving and all those things that you said. I'm just wondering about the discrimination now.
Well, excuse me. First of all, I didn't talk about a rule against aggressive driving. I have yet, and I say yet, almost 2 years now, I have yet to hear one specific complaint of anything I did wrong. All I've heard is a bunch of generalizations, except for 2 phone calls to the original complainant who isn't party to this, apparently. Everybody else I've talked to has never seen anything, done anything, or heard anything in regards to me other than conversation I had on the phone. And that, for the most part, would be the club president, the previous club president, which for a long period of time, by long, probably at least a couple of months, I had some belief that I was going to be able to work a problem with him. But in the end, once the original complaint was made and the evidence was available that I had done nothing wrong, this is a situation where everybody just stuck on what they had. Now, what their actual thinking is, I don't know, because I've never seen anything other than the third or fourth party, because I don't know how many hands that statement actually went through that was provided by the attorney for the defendants.
Thank you, sir.
Commissioner O'Brien.
Thank you. First of all, Mr. Walton, thank you for your service. I think what we want to hear from you is the fact that you are a disabled veteran, and what makes you say that because of your disability, that's why they won't let you race?
Well, let's put it this way. I'm not a woman. I'm not what would be considered a minority in regards to race or culture or anything else like that. I could not come up with any explanations for why they did what they did. The fact that the race director was angry when he got wrecked, I can understand that. That happens all the time. That the guy that wrecked him was willing to blame me rather than take the heat himself. I can understand that. That happens all the time as well. But once we got beyond that, then after that, I could see no reason whatsoever that made any sense other than the fact that they were aware that I was a disabled veteran, and not only my disability, 70% of it was an adjustment disorder. So basically, we're talking about, and I used to say things around them like, "Yeah, don't worry about me. I'm just crazy." So maybe they took it to heart. I don't know.
All right, thank you.
Commissioner David.
Mr. Walton, yes, thank you for your service, sir. Why didn't you go to that directors meeting and initially make your argument?
If it's in the record.
That's where I got it, but
Okay.
he didn't go.
I think
Well,
the reason it didn't go may not be.
And I actually had filled out that I had provided that information in the most recent response, and it was back to me I think it was emailed to me blacked out.
Okay, all right. I got it. I got it.
All right.
And the other thing that I wanted to ask you is, there is a rule against aggressive driving, isn't there?
I'm sorry?
There is a rule against aggressive driving, is there not?
Yeah, but when and where did that happen? I'm still waiting for somebody to tell me that. When and where did that happen?
Yeah, but that's the point, is that you're asking us sitting here to make a conclusion about the actual driving and whether it was aggressive and who caused the accident. And I don't see how that we can do that.
Well,
and you're just asking us to assume
you were given access to the video that would clearly show that I wasn't responsible for that wreck. And they've never ever said, the club itself has never ever said that that's the issue. All they've used is a generalization of aggressive driving. And I don't know what that means. First of all, and I don't know if anybody did the timeline while they read the evidence of what I sent you. The first race that I ever went with them was around August 20th of that year. And my car wouldn't start for the feature, so I never raced against them. The second one was at Oxford Plains, where I actually passed the guy that filed a complaint against me. And there was nothing was said there. The third race was in Bangor. He didn't race in it, but his car and two others were involved in two scrums that I am getting caught up in receiving damage from, but I didn't have anything to do with them. The last one at Lee, which was less than 40 days total from the first time that they saw my race car to the last time I went to the club, that event at Lee, which was the last one, I just think it was somebody made a mistake, blamed me for something, and then when they realized they'd made a mistake, what they decided to do was double down. That's all I can see with evidence. There has been nothing else. I don't know. I really don't understand what they're trying to do. Other than just, say sayonara, we don't like you're a disabled vet. Too bad. See ya.
Any other questions for complainant? Seeing none, Mr. Walton, you'll have about 4.5 minutes when we come back to you. Attorney Mellor.
Thank you.
Apologize if I'm mispronouncing your name.
You're fine, thank you. Thank you for being here today. And the president at all relevant times is here. President of Wicked Good Vintage Racing is here. As I think you've ascertained, the club Wicked Good Vintage Racing is a broader umbrella. Outlaw division is where Mr. Walton was racing and participating, and it's an exhibition racing division, and it's meant to be put on a show for the fan, let the fans see the old cars going around, and it's not meant to be competitive. It's not meant to be aggressive, and there were multiple instances on the track and off the track where Mr. Walton's behavior was just not appropriate, and on the track unsafe. It's really that simple. And I'll reserve the remainder of my time, but I'll stay here for any questions that you might have.
Questions for Attorney Mellor?
Do we have that video? Is that in the record?
I believe that I've seen pictures that were taken from the video. I don't know. We didn't provide the video. I don't believe. I think that was Mr. Walton's evidence. I will also add. So no, I don't know. I have seen pictures of the video. It may have been a Facebook video, and there was a discussion about disagreements about.
May I interrupt here?
Mr. Walton, this is not your time to speak.
Right.
We'll come back to you after Attorney Mellor has made his presentation.
Who delivers the news to him that the decision's been made that his behavior is unacceptable in accordance with the rules for that division?
There was a meeting of the board of directors, and I believe the president, Mr. Smalley, wrote a letter.
After that accident?
It was after the accident. It was after a number of instances, but including the accident. And there are multiple veterans, including disabled veterans, who participate in the Wicked Good Racing family. There's never, I mean, those individuals, I mean, there's never been any indication that there's any issues with veterans. Quite the opposite, as you might imagine. I mean, they're appreciated and welcomed with open arms.
Investigator McCarter is saying that there was not a video submitted in this case.
There was not.
Yeah. Any other questions for respondents counsel? Seeing none, we'll have 9 minutes when we come back to you.
Thank you.
Mr. Walton, you have 4.5 minutes if there's anything else you'd like to add.
Yeah, that video is available on YouTube at the address 2 Flakes Racing, 10122. If you plug a laptop into a TV, you would see it at large enough screen to see that I was several feet from the accident when it actually occurred. But let's get beyond the accident, because there's evidence to show that I had nothing to do with that. The defendants and the attorney basically said the same thing that was in his statement, which is they, this, yada, yada, whatever you want to say. Not one specific instance of anything that I did wrong that was reported to me in any way. And part of the problem with that is because we're only talking 30 days, and the only guy that was ever at all those events was the driver of the 79. He was the race director. The other 2 race directors that were part of that were probably at Bangor for that event, and one of those race directors was involved in 2 incidents of aggressive driving that resulted in 3 car crashes, and the other one, who was the owner of the 80 car, hit me in the rear after the 2nd incident. So that's okay. I don't have a problem with that, but I'm still waiting to hear what are the specifics of what they said that I did was aggressive driving. I don't understand that. That's what racing is. And even with all that, I wasn't making contact with other race cars. Other race cars were doing it to themselves.
Thank you, Mr. Walton. Any further questions for the complainant? Great. Seeing none. Attorney Meller, you have 9 minutes if there's anything you'd like to add.
I'll wait my time. Thank you.
Great. So we've heard from the parties. Next, we'll hear from Carrie McCarter, the investigator assigned to this case.
Good morning. My name is Carrie McCarter. As the executive director said, I am the investigator assigned to this case. Nothing that I've heard here today changes my recommendation. And I am here for any questions that you may have.
Any commissioner questions for the investigator? Seeing none, thank you, Carrie. We've heard from the parties and the investigator. At this time, we'd be looking for a motion. There is one proposed finding. Commissioner David.
I move that we find that there's no reasonable grounds to believe that respondent Wicked Good discriminated unlawfully on the basis of disability, and the complaint should be dismissed. Second.
Been moved and seconded. Any discussion?
Well, I just want to say to Mr. Walton that he's asked us and said that he can't understand why this action's been taken against him, other than the fact that he's a disabled vet, because he's not a member of some other group that's often discriminated against. But that's not sufficient, Mr. Walton. We need some evidence, would need some evidence from you tying their action to your disability. That's what this commission does, and that's the reason that we're supporting that the motion is on the table, to support the conclusion that there's no tie to unlawful discrimination.
Can you still hear me?
Mr. Walton, this is your time for presenting is done. This is just the commissioners discussing their motion, and then they're going to vote on it. Any further discussion? Seeing none, the motion is to find no reasonable grounds. If you are in agreement, you will vote yes. Commissioner David.
Yes.
Commissioner O'Brien.
Yes.
Commissioner Walker.
Yes.
Commissioner Douglas.
Yes.
Commissioner Sanders.
Yes.
All right. So the findings are no reasonable grounds. We appreciate everyone's participation, and the commission will send a letter to the parties and the council confirming the results of the hearing.
Thank you for your time.
And the last matter is Samari versus United Ground Express, E23-0096. It's a recommendation that we find no reasonable grounds, and therefore we'll hear from complainant.
Mr. Samar,
Good morning to you all.
you have 10 minutes. Would you like to reserve any of your time?
May I reserve 5 minutes, please?
Sure. All right, if you don't mind waiting just 1 minute, Commissioner Sanders just went to get some water. She'll be right back and then we'll get started.
Thank you.
All right. Whenever you're ready, Mr. Samar, go ahead.
Thank you, and good to see you all this morning. On August 5th, 2022, I was hired by United Grounds as a ramp agent. Before then, I saw the ad on Indeed, which talk about $2,000 sign-up bonus. That was very attractive, so I did apply. I went through the hiring process, did everything that they required, backgrounds, drug test, everything, and was offered the position. Prior to that, I had reached out to the hiring manager at the time, or maybe still is, I don't know, that I need a week to take a week off from where I work. At the time, I work for a housing company. I was a housing manager at the time. It was accepted. She told me that the station supervisor was willing to work with me. And so I was scheduled to appear on the 12th of September for my orientation. And the orientation was scheduled to start at 9. I was there by 8:45. And I had notified them that I'm here. So I was at their lobby waiting, and somebody escorted me inside. Then we did all the hiring process. They took my IDs, we went everything. And then they put me into the system and I was rejected. They tried a few times and it didn't work. So the office manager named Maya asked me to leave, that they will work on it, but it's not my fault. And I left that very day. I was there from 9 o'clock to like maybe 11 o'clock. So I went home. I live in Auburn at the time. Then the following day, I called them if I had to come back. And they said, no, I have to wait. Somebody will reach to me. Nobody reached to me. The third day, I went back again. And I asked to speak with the station manager, Mr. Tim O'Brien, who was new at the time. And he didn't, you guys can look at exhibit, you can look at exhibit C. That is how I appeared. If you have that on your, I have submitted all those for record. Based on my appearance in September, as a son of a traditional ruler back home where I was born in Ghana, it's every September we celebrate certain culture or traditional. So I wore that. I have to wear that the whole week. Not only that thing, but I have a couple of them I do change. I believe that was not, or it he was not impressed with my appearance in his office. So he asked me to leave, and I said, and reapply. And I said, I just been accepted. Why do you want me to reapply? That did not sit well with me. So I went home and I called Maya again. And she's like, no, it is our fault. We're still working on it. The whole week went by. I didn't hear anything from them. I called them. Nobody responded. So I tried to reach to a lawyer. And the attorney told me, if they said apply, reapply. So you guys, again, you can look at Exhibit E. That was indeed, I reapplied on September 27th. Nobody responded. So if he had kept me in his office, based on my appearance, asked me to reapply, and I reapplied, you did not indeed had notified me that the employer read your information. So the lawyer sent a letter to the, I think he's the human resource manager named Patrick. And you guys can look at Exhibit G, where Patrick had written.
Oh, Mr. Samar, please don't
Yes,
use the
ma'am.
names of people who aren't parties to the case.
What's that?
Please don't use the names of people who aren't parties to the case. You've
Okay,
referenced a
but,
couple of people.
well, sorry. I'm using those names because they were the people that we were coordinating at the time. So if that is
I
against your
understand
policy.
that. We have the rule at the commission, and in fact, the law says that the names of those people must remain confidential. So
My
this is a public
apologies.
meeting, please don't use their names.
My apologies, sorry.
Sure.
So we had received a letter from him. Clearly, the letter is not true. He said I was not an employee because I don't have I-9 or I-90, and you can look at Exhibit H. I have that.
That's your 5 minutes. Do you want to keep going?
Okay. Maybe can I go a little bit more?
Sure. Yep.
Okay. So I looked at all those things. So when my attorney, we had filed that against, we went on so many deliberations, and at some point, my attorney asked them to pay $35,000, and they declined, and they accepted to offer me $2,500, and I said I am not going to accept $2,500 because this is a violation. If you do not commit a crime, why are you paying somebody? So these questions, I wanted to get answers from them. I'm not getting answers from anybody. So that is why I persisted to understand why United Grounds will pay me $2,000 if I have not committed a crime. And under many laws, I have done all the due diligence that I have gotten accepted. We calculated all the expenses. The time I wasted there was supposed to be over $2,500 again. They did not pay me for my time, even though Maya had told me that if I'm getting paid while I'm not doing this. They didn't pay me anything. So I cannot waste my time for over 40 hours doing this work for them. They will not pay me. Secondly, they clearly lied that I don't have this. I was not an employee. They asked me to resign. I am not an employee. How do you ask somebody to resign when they are not an employee? All these are clearly not true.
Thank you, Mr. Samar. Any questions for the complainant? Commissioner Douglas.
Good morning, sir.
Yes, sir.
Yes, so maybe I missed it in your comments, so I wanted to ask so it's clear. The report says that you were supposed to go to new hire orientation on August 29th, and that you failed to go there. Do you agree with that? And if you didn't go, why didn't you go?
Thank you, sir. That is not true. I think we also provided evidence that I had text Crystal White, who was the hiring director, that this is the time, and she said, "They fine." I have provided that information. So I was now scheduled to start on the 12th. That's not true what they're saying, because maybe there was miscommunication between management themselves, but I had reached out. I have the text messages I think I provided to Angela, but that the conversation that I had with the hiring manager. So clearly it's not about you missed this. If I had missed it, let's assume I missed it, they should have notified me that, call me, you have my number, say, because you missed this, we are not hiring you anymore. You don't let me come to the office and you do all these processes. And because of my appearance, the manager has instructed them to not hire me. That is my opinion. Because you cannot just kick me out of your office like an animal and say, go and apply again. And I apply, and nobody responded to me. I've never heard this my entire almost 30 years in the United States, working everywhere. I've never seen this before.
Thank you, sir.
And Mr. Samar, I'm sorry, I misunderstood some of your presentation. Any settlement discussions that you and the respondent had during the process at the commission are also confidential, and we cannot discuss those here. They are not part of the record. All settlement discussions at the commission are confidential by statute. I apologize. I thought you were discussing something that had happened before you filed your complaint, and so I didn't say anything.
So
I should cut you off there.
With all apologies, if those are confidential to you guys, and when during the conference with Angela, I tried to bring that up, and later on we had a brief talking about it. So if that is not applicable, I just wanted to know why are they willing to do that if they have not committed a crime? Because it should be part of the case. I cannot say I'm going to give somebody something if the person has not worked for me.
Sorry.
Would you mind if I address that?
Sure.
Yeah. So just to address this whole settlement piece of it, right? All right, you said why shouldn't that be part of the case? I want you to understand, right, that first of all, settlement discussions would not be admissible in any court in Maine. There's a rule against that, okay? And so somebody tried to bring it because of what you just said. It's problematic when somebody says, well, I'm gonna, I offered to pay you to make this case go away. And the reason why it's problematic, sir, is because people offer to settle cases for many different reasons. I can tell you, I've been practicing law in Maine for 20 years. Every settlement agreement that my client has signed, pretty much without fail, has a clause in it that says that the party paying the money does not admit any liability against the settlement of a disputed claim. It is the standard provision. So I just wanted to sort of provide that background to you as to why these things are confidential, okay?
Yes, sir. I agree with you, but I did not sign that agreement. So if you agree and sign, that makes it confidential. In this case,
Mr. Samar, it is all settlement discussions that occur during the investigation at the commission are confidential by law. It is in our statute that those discussions are confidential regardless of whether an agreement is reached. The discussions themselves are confidential and we cannot discuss them in this meeting.
Okay, so
I don't think there's a question for you on the table right now, although Commissioner David is about to ask you one, so I'm going to move to him.
All right, thank you.
Mr. Samar, if I understand correctly, there's a dispute about communication and whether you showed up to the orientation or did not. They're saying you didn't complete the hiring process. My question is, I believe that they say that they gave you another opportunity to start again and to go back and reapply. Is that true?
That's part of the lying. I hate to call some people lying, but let me use the word, it's not true. I have that, if you look at that letter, he said they tried to reach out to me and give me a second chance. Who, when, where? Those were the questions I was expecting somebody to have follow up with them. Who did that? Is that through a phone call? Where is the record? Was it an email? Where is the record? Was it verbal? Who was there? Even if these are all part of the lies that they are trying to throw against the wall and expect it to stick. And you cannot say you asked me to write a resignation letter when you say I am not an employee. I don't know. I've never heard that. You guys are the experts. how will I resign when I'm not an employee?
They say that was in order to allow you to be rehired if you applied again. That the reason that, well, sir, you're saying that you don't understand it, but they're saying to you, if you resign, instead of having the record show that you failed to complete the process, which would make the entry you're not eligible for rehire. If you resign, we'll take that away and you can start again. Is that not correct? Is that not what you understand?
That's not true. I want to know who said that and when. That is not true.
We'll ask them. Thank you.
Thank you. Please follow up with evidence of that. I'll be happy to see that.
Any other questions for the complainant? Seeing none, Attorney Whalen will move to you. Mr. Samari, you'll have about 3.5 minutes when we come back to you. Attorney Whalen, you have 10 minutes. Would you like to reserve any of your time?
I'll reserve any time that I have remaining.
All right, whenever you're ready, go ahead.
All right, good morning and thank you all. I'll keep this brief because I believe that the facts are relatively short here. United Ground Express maintains a policy that all new hires must complete an orientation within 2 weeks of their start date. This is because there are heavy federal regulations, airport regulations, as well as company regulations that all employees must be familiar with before they enter the facility to begin their first day. Here, at least twice, United Ground Express informed Mr. Samari that he had to complete his new hire orientation as part of the onboarding process prior to his September 12th start date. This was communicated to him in his offer letter, as well as via email, that he needed to attend the new hire orientation on August 29th. Mr. Samari did not appear for the new hire orientation on August 29th, and he was marked ineligible for rehire because he was considered to have abandoned the job. When Mr. Samari did show up to the station, as he referenced, there was confusion because he could not be located in the system because of his ineligibility for rehire as job abandonment. They asked him to come back the next day, and when Mr. Samari returned the next day, he spoke with the manager who tried to work with him. The manager offered him the opportunity to submit a letter, which colloquially he called the resignation letter, to be able to reverse that ineligibility for rehire in the system. Mr. Samari never submitted that letter, and he was never able to apply for a job at United Ground Express again. So overall, the facts are simple. Mr. Samari was not discriminated against on any basis here. He did not attend the first day of his job, and he was marked ineligible for rehire for job abandonment. That's United Ground Express position, and I'm able to answer any questions you have.
Commissioner Sanders.
Good morning, thank you. Just one question. Your client's practice of marking somebody as ineligible for rehire if they don't appear for new employee orientation, is that a policy that's consistently applied to all of those who find themselves in those circumstances?
That is correct. Yes, it is contained in the job abandonment within the handbook. Considered job abandonment within the handbook.
And the remedy, well, this is 2 questions, so apologies. I told you I'd ask only one follow-up. The remedy that the manager offered, right? It's articulated here that if he wrote and submitted a resignation, that ineligible for rehire designation would be removed. Is that also embedded in policy, right? Is that a remedy that folks who find themselves in those circumstances can avail themselves of? I guess in other words, I'm asking, would that remedy have been effective?
So to answer your question, in short, there's no policy that says that's an effective remedy that everyone must administer. This was a favor that was extended by my client as a result of Mr. Samari's appearance 2 days at the station.
Any other commissioner questions for respondents counsel? Okay, you'll have about 8 minutes when we come back to you.
Thank
Mr.
you.
Survey, you have 3.5 minutes left. If there's
Yeah.
anything you'd like to add.
Yes, can I ask Mr. Whalen, why would
No.
the man,
Mr.
can I
Survey,
go?
you can't ask Mr. Whalen questions at this time.
Okay, let me put to the commission. I want to know if Mr. Whalen was doing me a favor, if it's not a policy, under what grounds? Somebody who was kicking me out of the office is doing me a favor, and here lies the case. We asked Mr. Samari, he didn't have I-95. Mr. Samari has one. We asked Mr. Samari to reapply. We asked Mr. Samari to resign. Nobody. I want to see evidences of those. Well, if it's a phone call, there has to be a record. If it's email, let's see that. If it's a text message, let's see that. Now, going back to that there was a confusion. There wasn't any confusion. The text message, then the confusion was from them in the management process, because Crystal and I had communicated that. Go ahead, please.
No, please don't use third-party names.
Okay, the hiring manager was the one that we were communicating. I'm sorry that, I'm sorry, was the one who was doing this, that I was communicating with. And I have text messages from her, from Angela, Maya, in the office. Those are the people who were communicating. You see, so this is just bluntly not true. And again, I don't want to say lie. I understand Mr. Willis' position. He's paid to do that, but he knows what he's saying is not true. He knows that. Because you cannot say that the station manager was doing me a favor. I'm leaving his office. I want his business card. He refused. Why wouldn't he write his phone number for me? What was the reason? And now he's doing me a favor because it's not a policy. Don't sugarcoat anything, please.
Thank you, Mr. Samari. Any questions for the complainant?
For me?
I'm just asking the commissioners if they have any questions for you.
Please, I'm ready for any questions.
We don't see any, so we will move to Attorney Whalen. You have 8 minutes if there's anything you'd like to add.
There's nothing further I'd like to add here.
We've heard from the parties, and we will move on to Angela Morse, the investigator assigned to this case.
Hello, my name is Angela. I am the investigator assigned to today's case. I don't think I have anything to add that I did not include in my report, but I am certainly willing to answer any questions that commissioners have.
Commissioner, questions for the investigator?
Can I ask a question?
No, not at this time.
Okay. Okay, sorry.
All right. Seeing none, thank you, Angela. We've heard from the parties and the investigator. At this time, we'd be looking for a motion. There is one proposed finding.
I move to adopt the investigator's recommendations in the recommendations section of the report.
Second.
Been moved and seconded. Any discussion? Seeing none, the motion is to find no reasonable grounds that United Ground Express discriminated against Sulemana Samare on the basis of race, national origin, and religion, and the complaint should be dismissed. If you are in agreement with that motion, you will vote yes. Commissioner David?
Yes.
Commissioner O'Brien?
Yes.
Commissioner Douglas?
Yes.
Commissioner Walker?
Yes.
Commissioner Sanders?
Yes.
So the findings are no reasonable grounds. We appreciate everyone's participation, and the commission will send a letter to the parties and the council confirming the results of the hearing.
Hands off of my calendar. Okay.
All right, so we just need a motion to settle PA 17-0424A and B and the related litigation.
So moved.
Second.
And to authorize me to sign for you so that we don't have to do this again next month.
Okay,
Great, thank you.
Commissioner David?
Yes.
Commissioner O'Brien?
Yes.
Commissioner Douglas?
Yes.
Commissioner Walker?
Yes.
Commissioner Sanders?
Yes.
Great. That's the end.
That's the end.
Our work here is done.
Thank you all.